Among the other factors you need to think about are, again, the skill overlaps between the original partners. For example, if you have two electrical engineers that are founding partners to a business, is it clear that one of them is going to go and take the CEO role and the other a chief engineer role? Because if not, the business may find that it doesn't have the skills that they need to continue. And then when you're adding on a third person for that business with two electrical engineers, if they're bringing in a third engineer, that third engineer should be worth a lot less to that business in terms of the stake that the owners are willing to give to them, because they have a lot of those skills already. And the business should be looking more to spend that equity stake acquiring someone with the business or operation skills that are more critical for the business. And again, decision-making styles, whether or not you have someone that wants to collaborate to make decisions, or if you have someone that just wants to decide and dictate the answer. And how do you resolve deadlock once you have it? Another thing to be aware of is that adding friends and family to a business can be quite risky. Can you be business-oriented with them? Can you keep on task? If there's problems with the business, is it going to take a toll on your personal relationships? And so these are all things to think about when you're trying to decide how you want those operating agreements to read, who you want to bring onto the business. And again, it's easier to come up with plans now when things are good, rather than waiting until there's problems down the road and no one wants to change the operating agreement. And so then the final question is, how much equity do you want to give that partner? To bring on a partner requires you to have some form of valuing of that partner's contribution. And when we're trying to value the contribution, we usually look to what have they brought in, their past contributions. What are the opportunity costs that that partner gave up in order to join the business? What are their expected future contributions to the business? And the founder motivations. Are they the key person that brought in the ideas? Are they there for financing? What are they supposed to be doing for the business? And then again, how long are they going to be there? Are they a short-term contributor? Are they going to be there and valuable to the business for the long haul? Again, are they going to be active or passive? Did they bring in property or IP or financing, or are they going to be doing the day-to-day operations of the business? But once you sort of have an idea of what the partner's contribution is, then you need to come up with a way to value what the business is worth. And this can be quite difficult. If any of you have taken finance courses, it's quite hard to value an established, mature business that's traded on the NYSE. It's extremely difficult to value a startup which has no sales, has only a couple founders, and is nothing more than an idea. And so there's a lot of negotiations that go on with deciding how much to give each person. But a partner doesn't just have to have an equity interest. A partner can come on and have commissions, they can have salaries, they have other financial incentives, and so you don't necessarily need to give them a 20% stake in your business. Perhaps that individual would be just as happy with a 10% stake and some relatively nice deals on how they get compensated on commissions for bringing in new sales. That frees up a little bit more money a little more equity to give out to other founders or to outside financiers. You can also change the type of shares that each partner gives. Perhaps they don't want dividends. Perhaps they don't want control of the business. And so there's, again, more things that come into play when you're going through these negotiations. And then next, how do you manage risk in a business? One of the biggest risks when you bring on a partner is that you sign on the dotted line that you give them 20% of your business and then they walk away. Once you've given them that equity stake, it's theirs. And so the risk that a partner leaves with key skills or key knowledge is hugely important to a startup. One of the easiest ways to ensure that they don't just walk immediately is to have the equity stake that you give them have vesting restraints on it. And so perhaps you give them 10% stake. Well, today you'll give them only 5%, but then you'll give them an additional 1% that they can earn over each of the next 5 years. And so that you can, if they walk away immediately, they don't get that entire sum of money. And hopefully you've secured, a 5-year commitment out of them. Again, like we've discussed with employees, the non-disclosure and non-compete rules also apply. You don't want your key partner leaving and then immediately starting up a competing business with you and trying to cut your legs out from under your startup. You can also look at the way that salaries and dividends and distributions are made. You can go ahead in your operating agreement, go ahead and say that perhaps if a partner isn't involved in the day-to-day, that they don't get their salary, that they don't get to take dividend draws. Obviously, the partner that's going to be signing on to this is going to find that a contentious issue. But again, it's better to think about just what you want protected, how do you want them to be compensated. As far as buyback rules, typically small businesses don't have set markets for their shares, and so who's going to buy their stake? The buyback rules say the small startup is going to repurchase those shares or that equity if there isn't an owner. And so those rules as well can determine whether or not it's convenient or easy for that partner to leave. And disassociation is the process whereby a partner actually leaves. And these rules can specify that certain conditions where it's wrongful for a partner to leave, and under what conditions they actually can leave the business under. And finally, intellectual property. Does that partner own the intellectual property that's key to the business? Are they walking away from it, or have they assigned it permanently to the business? It's again another thing that you need to keep in the back of your mind when you're going through the negotiations. One of the other risks that you face is of management conflict. And to manage conflict, one of the easiest ways is to avoid it completely. You can give people non-voting shares so that they don't have a say in the management of the business. They get their equity stake, so they're sharing the growth of the business, but they don't have any say in the management. You also can look to the board of directors or perhaps an outside advisory board of counselors to help the partners break deadlock. And the advisory boards can be more arbitrators where they tell you what the rule should be when two partners are in conflict, or they can be more like mediators and help you, the existing partners, discuss what to do, but ultimately the decision is still theirs. And again, we saw earlier the corporate events. You need to review the voting rules for each of those events so you understand the mechanics that they operate under. And another risk of bringing on a partner is what are the tax consequences. In a corporation, because you're reallocating shares or you're issuing new shares, it can create tax events. And if that partner is coming in and bringing in property, then it adds certain tax events into the addition of that new partner. And for an LLC, you're talking about a buy-in usually, and that again will have more tax consequences. And so it's important to talk to an accountant as well to make sure that you understand exactly what's happening when that partner comes on. And so everything that we've looked at so far looks at what the business is looking for in their partner when they bring them on. But that new partner is going to have issues and concerns of their own that they're going to want to ask the business. And typically they're going to be a minority holder. And so the minority interest is usually interested in finding out how the director and the officer voting rights are. The board of directors can be voted on per seat, or they can be voted on as a group. And so it's important to understand which way you end up voting, because if you vote everyone together, you have a little bit easier time getting people on. If they're voted one by one, basically if you have a 51% holder in your business, they get to elect every member of the board of directors, because each seat that's open will have all the shares vote on it. And so again, if you have 51%, you get to vote each seat. If they're all together, then you only get to vote your total number of shares. And so a minority shareholder can actually get seats under that voting method. And minority shareholders will also be much more interested in performance standards and the capital expenditures of the business, so that they can be sure that that the business is not being cashed out either by dividends or by excessive salaries, so that they know that they're getting the financial compensation that they signed up for. They're also going to be very interested in how the business chooses its valuation. evaluation method. And so, the negotiations are, well, my contracts professor once said that he'd accept any price so long as you took his terms. And so that's kind of how the negotiations for partners goes. There's a lot to talk about, and it's all the details. But next I'd like to turn it over to Jackie to talk about how you work with an attorney.
Just as a quick little wrap up, obviously there's a lot of information. There's a lot of things that you need to think about when you're hiring a new partner, an independent contractor, an at-will employee. They're all very different. They all have their own needs to fulfill the requirements, and there are tax consequences for everything that you do, which is why it's very crucial that you speak to an attorney, especially if you're a budding business. It's very easy to think that you're doing the right thing, and I don't know if any of you have ever had to try to fill out tax forms and send in your FICA and FUTA. It's the most horrible experience you'll ever have, and it's very daunting, and you think you get it right, and you have to turn around and refile everything. It's a mess that you would rather avoid, and problems like this that we've demonstrated today can compound your issues, and it's just easier to take care of it at the front end than try to fix it at the back end. So what should you do when you're working with an attorney? You need to ask who the attorney is working for. You may be the business owner, but most likely that attorney is working for the best interests of the business, and you'll have to read your engagement letters that you get from that attorney. Most likely it'll outline exactly what work that attorney is going to do, who the attorney has been hired by, which is generally you as the representative of XYZ company. And that's important because if you're bringing on a partner or any employee, and you're going to these mediations or these discussions, that attorney is looking out for the business best interest, and that may not be in alignment with what you think is your best interest. And the attorney should always advise you to get your own counsel, and that creates a problem because do you want to pay 2 attorneys to do something that you thought one attorney could do? It gets expensive, but it's something that if you're genuine about your business, if you are concerned about your interests, it's always good to have another attorney look it over to make sure that you are covered. And the other person you're working with should do that as well. You each have the ability to do that, and that should all be outlined for you. Read and understand everything before you sign it. It seems very simple. You'd be surprised how many people don't do it. And just as Ryan said, you may find yourself in a situation where you're using a default rule that is adverse to your best interests. And if this is your company, you don't want to take that chance that you are being forced into a provision that you had never agreed on. Do you want to have a 50-50 split with somebody that you sold 5% to? That's a pretty big deal in your business, and so you need to be careful and watch what you're doing before you do anything and you set yourself up for a big problem. Also, think about the kind of services that you want. Are you wanting or are you expecting to go to an attorney and to get forms right now? Because if you get them right now, most likely you'll get a good form, but it's not going to be tailored for your specific business needs. A lot of these law firms, they have forms that they have used. They're good forms, they're reliable, but they may not take into consideration exactly what your line of business is and what you need to make your business run smoothly. Whereas if you take some additional time with an attorney, it's going to take long. A lot of times people are impatient. I'm very type A, I am very linear. I'm impatient. I don't want to wait. But maybe that's best for you. Maybe it's good to take that extra time right now and maybe pay a little extra money to have somebody take the time and to be careful going over your documents. And finally, the attorney is going to offer you options. They're going to say, you can do this or you can do that. And a natural inclination is to think, well, I'm paying you, you're supposed to tell me what to do. But that's not what an attorney is there to do. They want you to look at these options. They present you with the things that you have the ability to achieve, and it is up to you to decide what works best under your circumstances. And you may have, the attorney only knows things that you tell them. You may have something that is irrelevant to the conversation you had 2 weeks ago with your attorney, but in the back of your mind, maybe you're thinking of your family when you're allocating this particular interest, and somehow that correlates to that, and you may not be as risk tolerant as option A would make you. Maybe you want to be more conservative and take option B. And an attorney can't make that judgment call for you. That's something that you have to decide on your own. So utilize them as a resource, understand that they're limited in what they can do, and it's all based on the information you provide and where you want to go with your